Welcome to Health Policy, Organization, and Finance. This is your Week 11 video. Last week, we spent some time discussing consent using minor consent as an example. This week, we discuss one of the biggest issues in public health, smoking. Smoking is not only controversial because it's so unhealthy, but because it injures not only the smoker, but the health of others around them. Public health professionals have to consider that even though smoking is unhealthy, it's probably not going to be outlawed. The reason for this is there is a liberty issue here, even if we're not sure what the liberty issue is or how to define it. Just like last week, this topic is meant to be an example. As with the other public health issues, keep in mind that what we're looking at here is the balance between individual rights and a community good. We know smoking kills. We don't need to get into the details of the harms of smoking because I'm sure all of you know them at this point. You can see the data on many different levels, many different websites, and in many different texts. And you probably are going to discuss that in other classes. What we're doing here this week is thinking about how we decrease smoking while respecting individual decision-making rights, that personal autonomy. Smoking, like many of our other topics, really falls under that police power. That's why it's been up to states to regulate it. Many states have made pretty broad smoking prohibitions, but no states have really outright banned smoking. What do you think would happen if a state passed a law that completely banned smoking? Outlawing cigarettes would be difficult. There's a lot of anti-smoking sentiment out there from the public health community and other health communities, but states really don't have enough support to pass such laws to even test this issue. Likewise, there's probably not a support to do it nationally, and there would be difficulty showing that the federal government even has the power to do such a thing. States have otherwise put up a lot of barriers to smoking, or what I call disincentives. These can include taxes, warning labels, age limits, limits on smoking areas, higher healthcare insurance for people who smoke. But no state has really outlawed smoking. For those of you who don't really like reading cases, there's only one this week. I've also added a law synopsis. The law synopsis is because there really isn't a U.S. Supreme Court case on smoking rights, and someone wrote this law synopsis to kind of go over the arguments that would come up if there was a federal Supreme Court case arguing this. So it kind of presents the legal arguments around smoking. The state case you have is Winslow v. Bartek. In 2006, Ohio voters passed a ballot initiative called the Smoke-Free Workplace Act. The law says that proprietors of public places of employment are not to permit smoking in their establishments. Zeno's Victorian Village was a bar in Columbus that had been cited multiple times for violations of the act. The citations were appealed, and so that's how it got to the Supreme Court of Ohio. Now, this case really illustrates that lawyers will throw a lot of arguments at the wall and see if any of them stick. In this case, none of the arguments really do stick, and the court leaves the law in place. But you really have a great example here of things that states would try to argue why you can't prohibit smoking. I don't want to hide the ball as usual, so I'm going to give you what I think is the most important decision in the case. The police power is inherent in sovereignty, and its exercise is justified by the necessity of the occasion. Its foundation is in the right and duty of government to provide for the common welfare of the governed. It is tersely expressed in the maxim, Salus populi suprema lex, or the health of the people should be the supreme law. If this reminds you of the Jacobson case, it's because it's very similar. The court obviously was thinking about Jacobson when they made this decision. In the law synopsis, the author argues that there is no constitutional right to smoke, and if there was, it would invalidate or frustrate all those state limits on smoking. We know that smoking isn't specifically mentioned in the Constitution, so if there was a right to smoke in the Constitution, you would really have to read it into one of those other rights listed. Most likely that would be argued that smoking was protected under that liberty interest, right? However, we don't really have any guidance, and there's really no reason to think that smoking is protected under the US Constitution. However, we don't know. Therefore, it falls under the state police power. So, let me just give you a quick rundown of state versus federal power. The Constitution, again, said that all powers not given to the federal government in the Constitution were given back to the state, and that is basically the police power. So if the state wants to make laws, rules, regulation, or policy about smoking, it falls under that police power. The only way the federal government could undo that is if it fell under a federal power enumerated in the Constitution. So, what this author argues is that doesn't exist. Therefore, this is solidly a police power. So, I hope I didn't confuse you. Thanks for listening. Really, the point of this week is that there's that balance between community good, community health, and personal autonomy and personal liberty, not just in vaccinations, but in all things that public health practitioners think about. As always, reach out with questions, comments, or concerns, and have a great week.